Good afternoon, people out there in Facebook land and out there on Google. This is Karen Harding Law from Auckland, New Zealand. Welcome to our media release on the issues to do with therapeutic jurisprudence. Today I'm going to read you some extracts from a book that I have written, and this is some of the research for it. This is a section on therapeutic jurisprudence. Well, what is therapeutic jurisprudence? Therapeutic jurisprudence is the study of the therapeutic and anti-therapeutic consequences of the law. Where litigants feel satisfied with court processes, believing them to be fair, they are more likely to comply with court orders and respect the outcome of judicial decisions, improving the integrity of the justice system. Embracing therapeutic jurisprudence as an underlying justice doctrine can enable processes to be developed that act as a therapeutic agent to maximise psychological and physical well-being. Therapeutic jurisprudence asserts legal processes can impact on the well-being of participants. It is used as a tool rather than as an analytical theory of law. It uses the behavioural sciences to study the therapeutic or non-therapeutic impacts of law. It takes into consideration that legal rules, procedures, and the behaviour of legal actors can either promote or harm the psychological and physical well-being of all participants in legal processes. Therapeutic jurisprudence uses the findings of such studies to suggest ways in which legal processes and legal actions can minimise negative effects and promote well-being. This is an approach to law concerned with the effect of law in action, not simply law on the books. The emphasis is on the law being a helping profession. The study of therapeutic jurisprudence has evolved over time, going mainstream internationally across the legal systems of many developed nations, embracing all legal disciplines and areas of law, including criminal law. When applied to the criminal justice system, it can effectuate improvements throughout the justice system for the benefit of court users. Therapeutic jurisprudence has become the theoretical basis of the problem-solving courts. Therapeutic jurisprudence promotes active engagement with people listening, being respectful, expressing empathy when appropriate, expressing support for rehabilitation plans, and using non-confrontational approaches. It draws on the research of the behavioural sciences. Offenders and perpetrators of domestic violence and parents of children at risk often have substance abuse problems and underlying psychological problems such as the effect of past trauma. Court processes, including the interaction with the judge, can either aggravate or contribute to resolving the problems. Where litigants feel satisfied with court processes, believing the process to be fair, they are more likely to comply with court orders and respect the outcome of judicial decisions, improving the integrity of the justice system. Therapeutic jurisprudence applied in the courtroom is likely to result in increased satisfaction from those involved in the court process. It is a tool that can be utilised in the specialist problem-solving courtrooms, in mainstream courtrooms, and also in smaller courts that do not have the structures to establish specialist courtrooms. Therapeutic jurisprudence has broad scope. If you'd like more information, I can refer you to a number of authorities. Michael King in his article, Innovation and Court Practice Using Therapeutic Jurisprudence in Multi-Jurisdictional Regional Magistrates Court. The Australian Institute of Judicial Administration, 20 September 2013 at pages 1 to 3. You could also see the book of David B. Wexler, Therapeutic Jurisprudence and Overview, 1999. Also, Michael S. King, Innovation in Court Practice Using Therapeutic Jurisprudence in Multi-Jurisdictional Regional Magistrate Courts, paper presented to the 21st Annual Conference of the Australian Institute of Judicial Administration, New Challenges, Fresh Solutions, Fremantle, 20 September 2013. Also refer you to Warren Brookbank's Therapeutic Jurisprudence, Implications for Judging, 2003, NZLY 463 at page 464. Susan Dyoff, The Comprehensive Law Movement, An Emerging Approach to Legal Problems, the Stockholm Institute of Scandinavian Law, 2010 at page 120. Also, David B. Wexler, Therapeutic Jurisprudence and Overview at www.law.arizona.edu/DEPTS/UPR-NDTJ-O.HTLM, 16th of October 2011. You might also find helpful to see the reference material of Mitchell B. McKinnon, MACKIENM, and Paul Higgins, Drug Court, Constructing the Moral Identity of Drug Offenders. Charles C. Thomas Publisher Limited, Springfield, Illinois, United States of America, 2008, at pages 30 to 31. That there is the end of that chapter. I hope you found that useful.